Welcome to episode 10. This is a discussion of Chapter 10 of UAE Crypto Litigation, available at www.uaecryptolitigation.com. So imagine this. You've just been acquitted of a massive, multi-million dirham crypto fraud.
Right, a huge relief.
Oh, absolutely. You walk out of the courtroom, totally free person, weight of the world off your shoulders. But there's a catch.
There usually is.
Yeah, exactly. The government is still holding all your physical cash from the transaction, and when you go to the civil courts to get it back, they basically refuse to take the case.
Because they view it as a criminal procedural issue.
Right. So you won your freedom, but you are completely locked out of getting your money back. So how do you actually get it back? What is the legal mechanism to force a resolution here?
Well, today we are going to dive into how a prominent UAE court untangled this exact jurisdictional nightmare.
And it really is a fascinating legal knot.
It is. And we are also going to look at why this specific type of scenario forced a complete evolution in how digital asset transactions are structured today.
Which is super important for anyone operating in this space.
Exactly. Our mission here is to objectively examine the legal mechanics of a determinative Dubai Court of Cassation judgment. We will break down how the judiciary resolved the immediate problem of the seized funds.
Right, looking at the actual legal framework.
Yes, and after that, we need to analyze how current virtual asset service provider, or VASP regulations, combined with sophisticated smart contractual architecture, are explicitly designed to ensure this specific scenario never happens to you in the modern market.
Which is the preventative side of things.
Exactly. And as always, just to remind you, this is an objective educational analysis of legal principles and regulatory frameworks. We're keeping it entirely neutral and focused purely on the mechanics of the law.
Which, honestly, is the best way to understand the underlying plumbing of this industry.
Totally agree.
So let's start with the facts of the dispute, which, frankly, sound a bit wild by today's standards.
They really do.
Right. So put yourself in the shoes of the claimant in this 2025 judgment. You walk into an unlicensed commercial premises, a jewelry store, of all places, carrying a really significant sum, nearly $1 million dirhams, in physical cash.
Just walking in with a bag of cash.
Yeah, exactly. And the goal is to buy tether. So you hand over the cash, but the tether never actually arrives in your digital wallet.
And, well, the informality of that exchange is the root of the entire legal dispute here.
Because there's no paper trail.
Right. The claimant handed over physical currency without any robust intermediate mechanism to guarantee the delivery of the digital asset. It was just a handshake and cash.
Which is a huge risk.
Absolutely.
Yeah.
So when the tether failed to materialize, the claimant logically filed a police report. But here's the thing. The moment law enforcement gets involved, the status of that physical cash changes fundamentally.
Oh, because it's no longer just a business transaction gone bad.
Exactly. It is no longer just money on a table. It becomes evidence.
Wow.
So the authorities naturally seize the cash and deposit it into the public prosecution's treasury, pending the outcome of the criminal investigation.
And here is where the timeline gets really messy.
Yeah, the criminal process has to play out.
Right. So the criminal court process happens, and the Court of Appeal ultimately acquits the respondents of fraud.
Because, objectively speaking, the specific, rigid legal conditions required for a criminal fraud conviction just were not met in this instance.
Right, but an acquittal just means nobody is going to prison. It doesn't automatically determine who legally owns the $1 million dirhams sitting in the prosecution's treasury.
Precisely. It doesn't solve the property dispute.
So naturally, the claimant files a civil lawsuit to get the cash back.
And, the assumption most people make is that a civil court will immediately hear the arguments about ownership.
Because it's a civil property issue now, right?
You'd think so. But that did not happen here. The lower civil courts initially dismissed the claimant's lawsuit entirely, labeling it as inadmissible.
Wait, they just wouldn't hear it?
Right. Their reasoning was highly procedural. They looked at the lawsuit and interpreted it simply as an administrative appeal against the public prosecution's decision to withhold the funds.
Oh, I see.
Yeah, in their jurisdictional framework, if you want to challenge a decision made by a prosecutor regarding seized evidence, you have to do that within the criminal court system, using criminal procedure, not in a civil court.
Okay, let's unpack this, because it's a fascinating legal roadblock. It's like the lower courts were acting as nightclub bouncers strictly enforcing a procedural dress code.
That's a great way to put it.
Right. Like, they looked at the lawsuit, saw the words public prosecution and seized funds, and immediately said, "You are in the wrong line. We only deal with civil matters inside this club."
Exactly. They were just looking at the ticket, not the person holding it.
Yeah. They refused to even look inside the claimant's metaphorical wallet to see if the money actually belonged to her. They just bounced the case on purely procedural grounds.
The bouncer analogy captures the jurisdictional impasse perfectly. The lower courts divested themselves of jurisdiction by focusing exclusively on the procedural framing.
So what breaks that impasse?
Well, the case was subsequently elevated to the Dubai Court of Cassation, which is the highest court, and they had to intervene with a determinative judgment.
Okay, and what did they decide?
The Cassation Court established a foundational principle of judicial interpretation here. They stated that a trial court is obligated to give a lawsuit its true description and correct legal characterization.
So looking at what's actually going on.
Exactly. The judiciary must look past the procedural label and examine the substantive reality of what the claimant is actually requesting.
So the higher court essentially stepped in and told the bouncers, like, look past the dress code and look at what this person is actually asking for.
Yes. The Cassation Court objectively recharacterized the entire lawsuit. They analyzed the core of the claimant's requests and determined this was, well, not merely an administrative grievance against a prosecutor.
It was something else entirely.
Right. The reality of the lawsuit was a substantive civil claim seeking to prove legal ownership of the seized money.
To clear it of any competing disputes, right?
Exactly, and to firmly establish the right to receive it.
Which is huge. By doing that, the highest court corrected a reversible legal error. They essentially pulled the case out from the shadow of criminal procedure and placed it firmly back onto the civil court's turf.
Which is exactly where a dispute over property ownership belongs.
Yeah, it ensures that when you are stuck in this bizarre limbo where you aren't a criminal but your assets are held by the state, you have a definitive, clear, procedural pathway to get a judge to rule on the actual ownership of your property.
And, the precedent set here is incredibly vital for the commercial ecosystem. It definitively confirms that the civil judiciary retains the authority to determine substantive title to assets held by the state following the conclusion of a criminal case.
Right, because otherwise,
commerce involving digital assets would carry an unacceptable level of unresolved risk whenever a dispute brushed up against the criminal justice system.
that perfectly sets up the pivot to the present day. Because, while the Cassation Court fixed this specific procedural mess, courts obviously do not want to be untangling multi-million dirham cash disputes involving jewelry stores on a regular basis.
No, definitely not. That is not an efficient system.
Right. So the regulatory environment had to evolve to prevent the mess from forming in the first place. So if you try to execute this exact transaction today, under the current Virtual Assets Regulatory Authority VARA framework, how does the system handle it?
Well, the current mature regulatory regime systematically deconstructs and regulates every single element of the transaction we just discussed.
So no more jewelry store handshakes.
Exactly. The informal handshake and cash dynamic is explicitly prohibited. Under the VRA Compliance and Risk Rulebook, a transaction of this scale is automatically flagged as high risk.
Which triggers a whole different set of rules, right?
It does. A licensed VASP is legally mandated to conduct Enhanced Due Diligence, or EDD. And this goes far beyond standard KYC or Know Your Customer checks.
Okay, so what does EDD actually entail?
The VASP must definitively verify both the source of funds and the source of wealth before a single dirham or digital token is ever accepted.
Wait, hold on. Here's where it gets really interesting, but also a bit tricky.
Sure.
I understand verifying the source of funds, like making sure the money being transferred right now isn't coming from an illicit bank account. That makes sense. But verifying the source of wealth for crypto investors, that can be notoriously difficult.
Oh, it is definitely a rigorous process.
Because, if someone's wealth came from early Bitcoin mining back in 2013, or from yield farming and decentralized finance protocols a few years ago, how on earth does a VASP verify that with a traditional paper trail?
Well, they don't use a traditional paper trail for that.
That seems nearly impossible to enforce in practice.
It is challenging, but it is the strict regulatory standard. VASP solve this by employing advanced blockchain analytics firms to conduct forensic tracing.
Oh, wow. So they actually track it all back on the ledger.
Exactly. If the wealth originated on-chain, the VASP will require the client to prove ownership of those historical wallets. They trace the transaction history to ensure the assets were not mixed with, sanctioned entities or darknet markets.
And if the money came from the traditional banking system?
If the wealth came from traditional finance, the VASP requires tax returns, audited financial statements, or proof of business sales.
So there's no way around it.
Basically, no. If the client cannot provide an unbroken, verifiable narrative for how they amassed their capital, the VASP simply cannot take them on as a client.
Wow.
The days of walking in with undocumented physical capital are definitively over.
Okay, so let's say I pass that intense scrutiny. I've proven my wealth, the analytics look good, now I want to fund my account.
Right, the actual deposit.
Yeah, let's talk about the physical handling of the money. Because in the court case, the cash was literally just handed over a counter.
Which is exactly what regulations are designed to prevent.
Right. Under current regulations, a VASP obviously can't just put your funds in their own operational safe or, a general company bank account.
Not at all. The physical handling is governed by strict client money rules.
Okay.
A VASP is entirely prohibited from informally holding client funds or treating them as corporate assets.
So where does the money go?
The regulations mandate that any fiat currency received from a client must be deposited into a designated, segregated client account at a third-party bank.
And they have a time frame for that, right?
Yes, within exactly 1 calendar day of receipt.
1 calendar day. That is an incredibly tight window.
It is, by design.
Why so rigid?
Yeah.
Like, what mechanism does that 24-hour limit actually serve?
Well, the rigidity serves 2 critical mechanisms. First, it prevents commingling.
Meaning mixing the client's money with the business's money.
Exactly. By forcing the funds into a third-party bank immediately, it ensures the VASP cannot accidentally or intentionally use your money to pay their own operational expenses.
That makes total sense. And the second mechanism?
Second, it creates an immediate, legally protected barrier against insolvency.
Oh, interesting.
Yeah, think about it. If the VASP goes bankrupt on day 2, your funds are already sitting in a segregated trust account at a regulated bank. They are legally distinct from the VASP's creditors.
So your money is safe even if the platform collapses.
Exactly. It creates a clear, auditable trail establishing the funds as client property at all times.
And the regulations don't stop at just safeguarding the money, do they? There are strict rules on the execution of the actual trade as well.
Absolutely. The VAA Market Conduct Rulebook establishes a comprehensive framework for execution.
Yep.
It makes a formal written client agreement a mandatory prerequisite.
No more verbal agreements.
None. This agreement must outline all services, fees, and communication protocols. And beyond the paperwork, the VASP is bound by the duty of best execution.
Now, in traditional finance, best execution usually just means getting the best market price for a stock, right?
Right. But in the digital asset space, it goes further. Its foundational premise is the successful, guaranteed settlement of the client's order.
Meaning you actually get the asset you paid for.
Exactly. Complete non-delivery, as happened in the case we analyzed, is the ultimate breach of that duty.
There is also a ticking clock on that settlement, isn't there?
There is.
Like if I place an order, the VASP can't just leave it hanging indefinitely while they try to source the liquidity.
Correct. The framework explicitly mandates that the final settlement of a virtual asset transaction must be completed within 24 hours of the transaction being executed.
But wait, what happens during a massive network congestion event?
What do you mean?
Let's say I'm trading an Ethereum-based asset, and the gas fees suddenly spike to ridiculous levels, slowing the whole network down. Does the VASP get a pass on that 24-hour rule because of technical issues?
They generally do not get a pass.
Really? Even if the blockchain itself is clogged?
Right. The strict timeline forces VASPs to build highly robust internal infrastructure. They cannot rely solely on congested public blockchains for settlement.
So what do?
They must maintain sufficient internal liquidity pools, utilize Layer 2 scaling solutions, or have guaranteed execution routes with major institutional liquidity providers.
Wow, they really have to have their plumbing sorted out.
They do. And alongside this, the VASP must generate mandatory audit trails, logging the exact amounts, timestamps, and specific wallet addresses involved.
Which completely eradicates the ambiguity of an informal arrangement.
Exactly. It replaces trust with cryptographic and regulatory proof.
It's a complete shift from relying on the honesty of the person across the counter to relying on audited, regulated infrastructure.
It's a totally different world.
But honestly, let me push back a little here. Even with all these rules governing the VASP, a contract is just a piece of paper if the assets are already sent to an unhosted wallet.
That's true.
Because once a blockchain transfer is executed, it is mathematically irreversible. So how do sophisticated commercial parties engineer their actual transactions to mitigate the settlement risk if they aren't using a centralized exchange?
That is a great question. Sophisticated commercial actors understand that a contract does not freeze a blockchain.
Right.
So they build robust transactional architecture to eliminate settlement risk entirely, which of course is the risk that you send your money, but the counterparty fails to send the digital asset.
So how do they achieve that?
They achieve this by completely replacing simultaneous trust-based exchanges with sequential intermediated ones. They use escrow architecture.
Okay, break that down for us. How does the architecture of that escrow actually function in a digital context?
It utilizes a neutral escrow agent. The buyer deposits the fiat currency into a traditional escrow bank account controlled by the agent.
Okay.
And simultaneously, the seller deposits the digital assets into a segregated digital wallet.
Is that just a regular wallet?
Usually not. They often utilize multi-signature technology, where the escrow agent holds the deciding cryptographic key. So the agent holds both sides of the transaction until contractually defined closing conditions are met.
I see.
The assets are only released upon verifiable joint instructions from the parties or a court order.
So it makes the non-delivery scenario we saw in the original case literally a structural impossibility.
Exactly.
Neither party can run off with the other's assets because neither party has access to both assets at the same time. The architecture forces compliance.
And it removes the temptation of default entirely. But, beneath that escrow mechanism sits a foundational legal layer of representations and warranties.
What do those cover?
Parties must legally warrant their good and marketable title to the assets and confirm they are derived from lawful sources.
So this contractual layer actively strips out the use of undocumented physical cash.
Yes, forcing the commercial transaction to align with those anti-money laundering standards we discussed earlier.
That makes a lot of sense. Now, let's look at the crypto side of the transfer, because this is where the legal world and the computer science world kind of collide.
It is a fascinating intersection.
Right. In the court case, the claimant argued the crypto had not entered her electronic wallet. So how do you legally define when a blockchain transfer is actually unequivocally done?
That's a crucial point.
Because if I'm looking at a block explorer and I see my transaction, is it legally settled?
Just seeing a transaction pending in a mempool, or, even included in a single block, is actually not enough.
Really? Why not?
Because public blockchains occasionally experience network reorganizations.
What does that mean for the transaction?
That's where two competing blocks are mined simultaneously, and the network eventually discards one in favor of the longest chain. If your transaction was in the discarded block, it is effectively erased.
Oh, wow. So you could think you got paid, but then the network just deletes it.
Exactly. So to solve this, modern transactional architecture utilizes a confirmation protocol.
So they are essentially translating the technical reality of network latency into a binding legal standard.
Yes.
How does a contract actually write that out?
It requires deep technical precision. A sophisticated commercial contract will state that a transfer is only legally deemed settled when it has been recorded on a specific block, and that block has been followed by a minimum number of subsequent valid blocks on the longest chain.
Okay, so it's not just one block, it's a sequence.
Exactly. For example, 6-block confirmations are often the standard for Bitcoin-like networks to achieve mathematical certainty against reorganizations.
And what about other types of networks?
For proof-of-stake networks, the contract might require the transaction to reach an explicitly finalized epoch. This provides an objective, publicly verifiable standard of performance that simply cannot be argued in court.
That is brilliant. And to tie all of this architecture together, you still have to connect the anonymous strings of letters and numbers on the blockchain back to real human beings or legal entities, right?
You absolutely do.
Because otherwise you just have a very secure transfer to a complete stranger.
Right. So the final piece of the architecture solves the pseudonymity problem. Contracts require parties to officially link their legal identity to a specific wallet address.
How does that work in practice?
A party will legally represent and warrant that a specific public key address is exclusively owned and controlled by them.
Oh, I see.
This creates an irrefutable evidentiary trail. If a dispute arises later, There is zero ambiguity about where the assets were supposed to go or who legally controls the destination wallet.
It really is a remarkable evolution in risk management.
It truly is.
So, wrapping up, today's deep dive showed us the entire spectrum of this problem. We saw how the Dubai Court of Cassation successfully untangled a massive jurisdictional knot, establishing the civil court's vital authority to look past procedural labels and determine the substantive ownership of seized assets.
A very necessary legal clarification.
Absolutely. And then we explored the mechanics of how current VASP regulatory frameworks, with their strict source of wealth verifications and rigid settlement clocks combined with sophisticated escrow architectures and confirmation protocols, are literally engineered to prevent these settlement failures entirely.
It's a highly robust system now.
It proves that as financial plumbing shifts from physical vaults to digital ledgers, the legal framework doesn't break down at all. It just develops much sharper, more precise tools.
The preceding case established a crucial procedural route for recovering assets held by the state after a failed crypto asset transaction, focusing on the civil court's jurisdiction to determine ownership of seized fiat currency. The claimant's title to the cash was relatively straightforward to assert. However, a recurring and more fundamental challenge in crypto asset litigation is the task of definitively proving ownership over pseudonymous digital wallets themselves. Without a clear chain of evidence linking a specific wallet address to a particular individual or entity, claims of ownership or misappropriation can be exceedingly difficult to substantiate. The next case examines this precise evidentiary hurdle, demonstrating that in the absence of a formal agreement or other corroborating evidence, courts will not infer ownership from on-chain transaction data alone. That brings us to the end of our discussion on Chapter 10. This chapter's structure is the standard methodology used throughout the book, authored by Mahmoud Abouessel, and drawing on analysis from over 100 judgments. UAE Crypto Litigation serves as an indispensable resource for those in the digital asset industry.
To read the full analysis for this chapter and to explore the complete 7-part life cycle of a commercial dispute covered in the book, please visit www.uaecryptolitigation.com.
The discussion in this podcast is for educational and informational purposes only and does not constitute professional advice or any other professional relationship. Please consult with a qualified professional for advice tailored to your specific situation.